Actually, somebody sent me in a question that they wanted me to ask you, so I'm going to read it from my notes, okay? So, if a legal permanent resident, so a green card holder, files an immigrant petition for an unmarried adult child over 21, and the petition is approved, but then the child gets married before entering the United States or before actually obtaining the green card, if they're in the United States, what happens to that immigrant petition?
That is a very good question because I see this happen all the time and people do this out of ignorance. The way the immigration law in the United States defines family is different from the way the English dictionary defines family. So for immigration purpose and to a US citizen, family actually includes the spouse, the parent, and minor children. That is the definition of family under immigration law. So your own biological child who is 21 years and above is not considered part of your family. It's actually, he or she is considered extended family member. Now, the reason this distinction is very important is because a permanent resident cannot petition in some limited, in a lot of ways, cannot petition for certain family members for this purpose under English dictionary. Let me explain further. A permanent resident cannot petition for a married child. That is reserved exclusively for a US citizen. So if a permanent resident submits a petition, whether the petition is approved or not, for an unmarried child, for as long as that married child has not obtained the permanent resident card, the green card, either through the embassy or physically in the United States, for as long as they have not received that green card, if they get married, that petition is terminated by operation of law. USCI does not need to do anything. By operation of law, if they get married, the petition is terminated on the day of the marriage. However, there's an exception. The exception here is if on the day of the marriage, if the permanent resident parent has become a US citizen at that time, the petition automatically changes category from unmarried child of a permanent resident to married child of a US citizen. Because a US citizen can petition for a married child, that petition is saved. But if the petitioner, the parent, remains a permanent resident at the time of marriage, that petition is terminated by operation of law. Thank you for watching. We appreciate it. Because our desire is to educate as many people as possible, we have decided to go live effective January 2023 so that we'll be able to answer people's specific questions. So please watch out for our live podcast effective January 2023. Thank you.